Good afternoon, everyone. I'm coming to you from BC today. So good afternoon. I'm sorry for the late start here. I'm sure as all we're all used to the technical difficulties with the remote world we've been living in, but we got everything sorted today. We've got a little less time than we'll usually have. Usually we'll have 30 minutes on this Facebook and YouTube live answer session. Today we'll have just a little around 20 minutes. So I'll get through the questions as quick as we can here. I want to just thank everyone for being here today. This is your chance to connect with myself, BC employment lawyer, and answer any of your questions dealing with any employment issues you have, any employment issues you may be foreseeing, or just any general employment questions you may have. And I've always wanted an answer to. Now's the best chance to get that answer. I do practice exclusively in BC. I realize there may be people from other jurisdictions here. You can head to our website or our Facebook page. I have colleagues practicing in Alberta and Ontario who do similar Facebook Live sessions who will be more than happy to answer your questions. Or, if you look at the bottom of the screen there, you can connect with us at employmentlawyer.ca to connect with one of our helpful lawyers or staff directly to answer your questions or set up a consultation. So I see we've got some questions coming through already. I've got a couple matters to kind of hit on, but let's start with the questions here. We have Tracy Ellis through Facebook who asks, in a union environment, I cannot hire an employment lawyer, but I can hire a disability lawyer. Coming up to the 2-year LTD mark, where status changes to any job. So Tracy, typically that will depend on with respect to an employment lawyer. Let's get that out of the way first. No, you cannot hire an employment lawyer. You are stuck with the collective bargaining agreement and the grievance process in that respect. When it comes to a disability lawyer, the answer is a little more complicated. I do practice in the disability area as well. And there is an opportunity in some cases to hire a disability lawyer. It does depend on the wording of your policy and your collective bargaining agreement. So we would need a look at those before we're able to answer any questions, for that. You can feel free to contact us at, like I said, employmentlawyer.ca. You can email us at help@employmentlawyer.ca with your documents, and one of our intake team will be happy to connect you with a disability lawyer who can review your matter and provide you with the advice that you may need with respect to your issue. Okay, and so we have another question through Facebook. Rick is asking, hello, is it legal for an employer to offer working termination for 1.5 years in lieu of severance? Thank you. So Rick, that's a great question, and the one I actually come across quite common. So severance is notice of termination. That is the base concept of what severance is to bridge you to new employment, but is notice of termination. And that notice can be provided in terms of working notice or payment in lieu of notice. In most cases, it's the employer's choice as to whether they're going to provide you working notice or payment for that period. What we look at is the length of severance that they're offering is the first step in the analysis to see if that is adequate. And that's really what severance looks at. Working notice is not typical, simply because when you've terminated an employee, most employers will not want to have that employee around in the workplace, but it does happen. So yes, to answer your question, it is legal for them to provide you with working notice, as long as the time frame they're offering you is appropriate and in line with your legal obligations. Typically, it's their choice as to what they provide you with. Now, the only caveat to that I'll add is if you have an employment contract that specifically states, you're only, entitled to payment, then that would change the analysis. But that would be very specific to your employment contract. So have a look at that. You can feel free to reach out to us and provide us a copy of your contract for a review, and you can go from there. Okay, and we have through Facebook, an interesting one here, VS 2015M through Facebook asks, I'm an employer. Can an employer in BC deduct amount from an employee's final pay with consent if they didn't fulfill a policy obligation, such as taking a course but not staying long enough. So VS 2015, that would depend on, I mean, generally you can't be deducting amounts from pay without consent. If there is consent, I don't see there being, that much of an issue if the employee is consenting, because they won't obviously then bring any action against you or have any issue with it. I think it would depend on the terms of the contract that you made with the employee for, I'm assuming, I'm assuming you as the employer funded their course. And they were then, the employee was required to stay for a certain period of time to allow you to recoup either the investment on that or the money on that. And so it would depend on that. But if the employee consents, generally two consenting individuals can agree to that, and that won't be an issue. And through YouTube, we have another question here by Andy McKinnon. Andy asks, what kind of changes to my work duties is my employer allowed to make? So Andy, that's a great question. With the pandemic and people working remotely and some being asked to come back in the office, this has been quite a hot topic as of late. With respect to the changes your employer is allowed to make, with your consent and your agreements and your negotiation, the employer can make any changes they want, as long as you agree to them. If the employer is implementing unilateral changes, then it becomes a bit of an analysis as to what is being changed. How does it affect you in a material way? Is it dropping duties that you're previously had? Is it lowering the prestige of your position? Is it affecting your income? Or could it affect your income in the future? Are you a commission-based employee where this is going to have an impact on your ability to take in commissions? So it's really an analysis that will depend on the specifics of your position, the terms of your agreement and your compensation package, as well as the duties that were outlined to you when you took this position or when you were offered this position and accepted this position. And the changes being made and how that impacts it. For example, if you're going from a managerial role into, and your employer is changing your role, not changing your compensation maybe, but changing your role from a managerial role to a supervisory role, where you would be working alongside people that you maybe had done performance evaluations for. You would be taking a lesser position in that case. Then you may have a claim for constructive dismissal. Provided you don't agree to that for some reason. There may be a performance enhancement or incentives that your employer is offering you to change your position. And with anything, I mean, you can change your position as long as you agree. So I would encourage you, if this is happening to you, to reach out to us with the specifics and the details, and to have a conversation about that, because it is a bit of a detailed analysis. And you can go to employmentlawyer.ca. We also have blog posts on there about constructive dismissal. That's what this would fall under, where your employer may be in a situation where they're changing your employment to a extent that they're no longer agreeing or they're no longer in a position where they're offering you or maintaining your employment in the manner that you were offered. So if you accepted a position for X position and now they've changed your position to such an extent that you're now working as Y position or another position, then that would be a case where you would have a case for constructive dismissal from your employment. So we have another question through YouTube. Clinton Fisher asks, subscriber here, is concealment a difficult situation to receive damages for? I was hired by a company whose employment contract omitted full details of the role. So, Clinton, I assume concealment, you mean that there was terms of employment that weren't outlined in your contract that are now attempting to be imposed on you. And that's kind of similar to what I guess Andy's question was. If offered in an employment contract, X position, and the duties were outlined in the contract as, the following 10 duties are what will comprise your position. And then you've taken the position, and all of a sudden your employer is saying, oh, by the way, in addition to these 10 duties that you agreed to, we're also lumping on these additional 20 duties. And it fundamentally changes your position to something that you would not have agreed to. Or if it just fundamentally changes your position, then you would have a case for constructive dismissal in that sense. And it would be sort of inducement maybe, depending on your specific situation. or at least misrepresentation as to the position, and you could be entitled to additional damages in that sense. It would really depend on the context of the negotiations, how your employment contract is worded, or how the duties and how the actual position was laid out to you in the first instance, and what you accepted based on. Similar to the example I used for Andy, if you were offered a position as a supervisor, and you took a position as a supervisor with pay commensurate with that type of a role and responsibility, and then you realize that after a month in the role or whatnot, you're getting additional duties lumped on that are managerial duties that are requiring additional duties that are saying that you're working outside office hours, you're working outside the hours you're required to, you're doing work you're not getting compensated for, then yes, you would have I would say you would have a claim for constructive dismissal. And sorry, I see Clinton, you just sent through a quit because of it, and they sent an ROE saying quit. So Clinton, it would also depend on the context and how you quit. With a constructive dismissal, typically how these are done is an employee will resign, citing the changes to their role, to say that I didn't agree to this role, you're breaching your employment contract with me, so I'm not beholden to this role anymore, and you owe me severance in this case. So it would really depend on the context on how you quit, and the manner in which you conveyed that to your employer, as well as discussions. If you had discussions with your employer about the changes they were putting into your role, and what the negotiation or conversations were around that. I would encourage you to reach out to us in that sense. You can email us at help@employmentlawyer.ca to set up an appointment with someone to go through the specifics of your situation. In this case, the details really do matter. But generally speaking, no. If you agree to X position, your employer cannot just unilaterally change that on you, and expect you to agree to that. Okay, Verdrana Torovic, sorry if I mispronounced that at all, Tordovrik, on YouTube asks, I was working at a nursing home in a unionized environment and got terminated with cause. Am I entitled to EI or severance pay? So, Verdrana, it really depends on your recourse. I mean, you would likely be entitled to, you may be entitled to EI. It really depends on the terms on which you were terminated on. If it's for cause, likely not. With severance pay, it would be determined by your collective agreement. We don't deal with union matters. We're unable to kind of give commentary on that, because it does depend entirely on your collective agreement that will govern the terms of termination, any entitlements on termination. For example, they may say, if you're terminated with cause, you're entitled to 2 weeks of severance. I have seen the odd contract where that is in there. So it really would turn on the wording of that. I would contact your union representative and have a conversation about that, especially if you dispute the alleged cause. I would speak with your union representative about that. Okay, Verdran, I see you have I didn't take the vaccine. So if that's the reason they terminated you, again, I would still speak to your union representative about that. I know there have been a number of labor decisions that have come out in Ontario and some in BC, I believe, that do deal with this issue, and in some cases they have upheld the termination. Now, I can't recall off the top of my head if they were for cause or not, but again, speak with your union representative, and that's the really way you have to go. And if you wish to file a grievance with that, then that would be the way for you to go with that. Let's see. So we have a question from JC204X from YouTube. And the question is, in the event an employer decides they don't like something you do outside of work, is there anything other than severance that would be owed? I heard about that woman doing online stuff in the US that her employment did not like. So JC204X, the name, by the way. I'm assuming that in this situation, your employer catches you doing something outside of work that they don't like, and then they terminate you for that reason. If they terminate you for that reason, I mean, whether or not the termination would be appropriate. It really depends on how they're terminating you. If they're terminating you without cause and they provide you appropriate severance, then there's really nothing you can do. If they terminate you for cause, which does happen sometimes, there's been recent cases of that. For example, there's blog posts on our website. You can go through. There's quite a lot of content on our website in terms of blogs and other live streams and employment law shows that will deal with this issue. But essentially, for termination for cause outside of the work, for conduct outside of the workplace, there's an analysis that's gone through, and typically it will turn on whether or not you were identified as a representative of the company. For example, if you were driving in a company vehicle and caught, driving intoxicated in a company vehicle, that may very well be cause for termination. Simply being at a protest, without any identifying markers on you as an employee, your employer can terminate you without cause if they pay you proper severance. If they terminate you for cause, it would really turn on the circumstances in which they've done so. So just because your employer doesn't like something you do in your private life, doesn't mean they can terminate you for cause, but it also doesn't stop them from terminating you. The real key is, are they paying you severance, and is it the appropriate amount of severance? In BC, an employer can terminate you for any reason they wish, as long as it's not a discriminatory reason, as long as they pay you appropriate severance. That is completely up to them. So I'm not sure if that answers your question. I think that's the best I can do at this stage. If you have any more questions, you can always pop in here and ask. So we have another question from Jean Everson through YouTube, asking, my supervisor laid off both my husband and myself after a protected activity. She stopped all communication after she responded. We are being moved to another team. I asked her, sorry, Jean, I think your question may have gotten cut off here. But in this sense, from what I'm getting from this, if you engage in a protected activity, I'm assuming you're in BC and you're talking about a WorkSafe BC, WCB protected activity, your recourse would be through WCB. And if they haven't terminated you and they're moving you to another team and this is impacting your employment, I would suggest you contact WorkSafe BC and discuss this with them. And you can file a complaint through WorkSafe BC for that. That would be your best way to go. Oh, sorry, Jean, and why no answer? I don't know why she wouldn't have answered you. That would be something you would have to take up with her. Again, I would simply contact WorkSafe BC and go through them for this matter. They will contact your employer and dig into the issue a bit, and your employer will have to respond to them in that sense. That's probably the best way for you and your husband to proceed, provided you're not satisfied with the move that are being made to another team. I don't know what that entails or what impact that will have on your employment or your work or compensation. And so we've only got about a minute or so left here. So let me see. FF asks through YouTube, can you please explain what falls under termination without cause and termination for cause? Okay, so this is a question. This is the heart of what we kind of look at. So employment, so termination without cause, and I'll try to get through this real quick. Termination without cause is there is nothing leading to your termination. Your employer may just decide that they don't need your position anymore. They don't need to have you there anymore, and they've just terminated your employment for one reason or another. They pay you severance. They owe you severance in that situation. A termination with cause means that the employer is alleging you have done something incompatible with the continuation of the employment relationship. You've, for example, assaulted a client or assaulted a boss, something in that. It's reserved for the worst of the worst conduct. The way the law looks at it is that the capital punishment of the employment relationship is there is no way the employee-employer relationship can continue. In that sense, you are not owed severance. So there are very few circumstances that actually rise to the level of cause. It's a very high bar. If you are facing a cause termination, contact an experienced employment lawyer. You can contact our firm. We're always ready to help. We would look at your situation and have to deal with that, specifically for your situation, each situation. Without cause termination, the main question is, what severance are you being offered and owed, and is it enough? That is the main analysis on that one. So I see we're at 1:31. Again, apologies everyone for the delay in the start today. And next, I'll be back in 2 weeks for BC. So I invite everyone to join me again, and I'll be more than happy to answer all of your questions at that time. And in the meantime, we will have my colleagues in Alberta, BC, and Ontario. Who will be on in the meantime in the next 2 weeks to answer any questions you have. Go to our Facebook page or our YouTube page. We'll have the invites there and the future sessions outlined there. So thank you everyone for joining me. I hope I was able to give you some good information and to help, and you're very welcome. And I look forward to speaking to everyone again. Take care.